So, welcome to the continuation of our SME seminar series. The last one of these I did was on the RACLA, the Commercial Leases Act. This one is going to be primarily on the Land and Business Arbitration. I can't think of the acronyms for that. Not as good as the RACLA. We're going to be dealing with the regulatory framework around the sale and businesses. And the primary act source for this is the Land Business Arbitration Act. Broadly, the Act is designed to create a regulatory requirement for significant disclosure given in connection with the sale of land. That's in the form of a vendor statement in Form 1, and very detailed disclosure to be given in connection with the sale of the business. That's Form 2, business statement. It's all about informing the buyer of interest that can affect land and business. There's a degree of complexity about this, but I will endeavour to keep this fairly light. I think we'll just start by referring to some definitions. The Act deals with sales of land or an interest in land. Now, a lease will include an interest in land. That is an interest that confers an inclusive right of occupation. That's what a lease is. But the Act isn't really getting to leases. The definition seems to include the lease, but it also has been qualified to refer to that interest or exclusive occupation as arising from some company title ownership, which was a fairly old-fashioned way that people divided up land years ago before strata titles and community titles. So it doesn't refer to a lease, even though that does give an exclusive right of occupation. It's only dealing with land, and it will also apply to a small business. A small business is any business in which there's a sale for a price less than $300,000, excluding GST and excluding stock. $300,000 doesn't seem like a lot these days. I'm not sure whether that was last amended, but it's not a great deal. It means that a lot of small businesses are changing hands with this no disclosure requirement at all. If you are dealing with the sale of land which includes business, then the value of the land is excluded from that $300,000 component. You disregard the value of land as looking at the total consideration for the land and the business. If you're not clear on what the value of the land is, then it's whatever, in that context, it's whatever's agreed. And if there's been no agreement, then it's the capital value as assessed by the valuer general. So we recently had a file in which there was the sale of land and a business for about $4 million. It was in our interest not to have to give a disclosure statement in connection with the business. It's quite onerous. Responsibility associated with it. But the difficulty is that most of the value was taken up by the value of the land, which was, say, $3.8 million, which means that the value of the business, by definition, was about $200,000, which means we had a small business. And we had to potentially give a disclosure in connection with the business. Right. But because the contract didn't provide any acknowledgement or agreement as to the value of the land, we simply relied upon the value of general value, which was 1.5, about 3.5 thereabouts, which by definition meant that the value of the business must have been $500,000, and we don't have a small business. So that's how it worked out. So you can have a bit of a definition issue as to when you're dealing with a land and a business, whether you've got a small business, how you work that out. As I mentioned broadly, the point of the Act is to require significant disclosure of interest affecting land in the business. The business disclosure is more detailed. We'll get to that in a moment. But you're also probably aware that there are cooling off rights associated with contracts for the sale of land and sale of land. The cooling off rights in connection with the land is 2 business days. That's called the cooling off period. It's actually not that. We'll come to that in a second. And for the sale of business, 5 days. So people think of a cooling off period as being 2 days. It sort of is, but it's not. What happens is that if you're entitled to a cooling off right, and there are some situations in which you're not, then you can give a notice to pull off and just get out of a contract for sale of land or business, no questions asked. Even if it's an unconditional binding contract, you just cool off and you're out of it. You have a written notice. And you have to give that notice any time up until a thing called the prescribed time. So it's actually not a period of time, you just give until the prescribed time. And in connection with the sale of land, the prescribed time will be 2 business days from the later of the signing of the contract or the service of the Form 1 disclosure statement. So, if we signed a contract today and you were given Form 1 today, then the cooling off period would be Friday, business day, or Monday. The prescribed time would be midnight on Monday evening. If, on the other hand, you signed a contract today, but you didn't get Form 1 until next Monday, then effectively that cooling off period is all of Wednesday. The prescribed time is midnight on Wednesday. And you can flip that over and talk about the form of being served today and the contract being signed next week. Same thing applies to a business contract, except that's 5 days. So the thing to bear in mind here is that it's not call it a cooling off period, but really it's a right that you have to cool off before the prescribed time. And the prescribed time will be a function of counting business days, third public holidays, from the later of these events. The events being signing a contract and the service of the Form 1 in the context of the sale of the business, Form 2, Form sale of land, and Form 2 in the context of the sale of land. There's significant leeway as to how you can go about giving this notice. You can email it, you can fax it, you can mail it. If it's mailed, then it's deemed to have been received, I think, 2 days after it's posted. You give it to the agent. In circumstances in which I've been giving a cooling off notice, it's good to fax it and mail it and send it to the agent and send it to the address of the vendor and contract, send it for everybody, because there can be issues as to whether it's validly given. And I've been involved in that as to which that is the case. It's a while ago where an argument that the purchaser dropped off the notice before midnight last day. Couldn't prove he did, couldn't prove he didn't. We dropped it off next morning. Who knows? Anyway, that was the story. That was just dropped off, and that was a career of uncertainty as to whether that notice had actually been given or not. I don't think it was, but we couldn't turn it. If the contract's cancelled because there's been a cooling off, then the vendor can only return $100 out of the deposit. And where the buyer is entitled to a cooling off right, then only $100 can be taken before the end of this cooling off period for the prescribed time. In the sale of a business, no more than 10% of the price can be taken as a deposit, which seems a bit odd because the sale of land you can take $100, and the sale of business you can take up to $30,000. Not sure why. So you have this unfettered right, as long as you give a valid notice, then the contract is signed without any further formalities. There are some exceptions to these, the right to call off. A company years ago did not have a calling off right at all. That was changed. So the contract entered into by a company to buy residential land attracts the calling off right, which is certainly fair enough. But if a company signs a contract to buy land which is not residential land, then there is no calling off right. Residential land is, yeah, sure, house block with a house on it, yeah. But also, it doesn't include land that's more than 2.5 hectares in area, which would imply that if a company buys a farm, it would not have a calling off right. So there can be a bit of a definition question as to what is residential land in the context of a company signing a contract to buy it. But by virtue of some recent changes, companies do have calling off rights for residential land now. There's another exception to this right, and that is that the buyer gets legal advice, and the legal practitioner signs a certificate stating that he or she has given that independent legal advice. Here, as many times. And the question is, well, legal advice about what? Certainly, the legal advice must be to the effect that as soon as I give you advice that you're not going to get a calling off right and I'll sign the certificate, then you're not going to get a calling off right. I think it's probably a bit more to it. And I think a proper interpretation as to what this advice needs to be about is that it should be about the contract, the terms of the contract. There's probably the Form 1 as well. The contract, the price, the inclusions, the exclusions, the settlement date, conditions, etc., those things. I think that's part of that discussion. And the Form 1, I think that's going to be quite detailed, but I think it's worth running through some of that. And then the certificate then so is to the effect that on the giving of that advice and signing the certificate, that needs to be produced, then there is no calling off. So what that means, and all this, by the way, needs to be done before the contract is signed. So if that is all done, then as soon as the buyer signs the contract, goes to the vendor, contract becomes binding when the vendor signs it, and that acceptance of the offer, which is the contract, is relayed back to the buyer again. That's when the contract's binding. And at that point, there's no calling off right. Same thing applies to the sale of a business. There can be a certification about that as well. There's an exception, further exceptions, where there's a sale of property by auction. That's self-evident. Can't have a calling off right in that context. Also, if there's a sale by auction and someone misses out, but then enters into a contract on the same day, no calling off rights there. If there's a sale by tender or the exercise of option, then there's no calling rights. And the implication with that is that you've been given full disclosure of the option right and the tender, request for tender normally, and therefore a calling off right is not appropriate. And in the case of a sale of business, if the disclosure statement has been served at least 5 days before the signing of the contract, then you've had 5 days with the disclosure statement Form 2, and therefore you don't get a calling off right then. And finally, if there's a sale of a business and the sale of land together, and the sale of the business is not a small business, there's no calling off right for that. So there are some exceptions to this whole idea of calling off rights. But in the ordinary sale of a domestic residence out there, other than by auction, there's a calling off. So I talked about prescribed time for land contracts and small businesses. Keep that in mind. There's reference to instalment contracts. An instalment contract is where there are more than 3 deposits paid before settlement. You can pay up to 3 deposits, but beyond that, it's an instalment contract and it's not law. We had a recent file here where it was the purchase of a commercial property for about $2 million. Only about $500,000 was paid as settlement. The remainder is paid interest-free by instalments over the next 10 years. Pretty unusual arrangement. But because we effected settlement when the $500,000, all the rest of it is just kind of in finance instalments. So that's not an instalment contract. An instalment contract will be where there are instalments of a deposit paid before the contract formation. As I say, the Section 7 Form 1 vendor statement for the sale of land. It sets out calling off rights. It sets out particulars for mortgage discharges and prescribed encumbrances. It can be very detailed. Here's the detail. It also sets out whether land is affected by any number of acts of Parliament, regulations that may affect land, environmental issues about whether there are EPA contamination assessments that might affect this land, or whether the vendor knows of any of that. That's relevant for a matter I'll talk about in a second. So you have to give one of these forms, and the question is, well, if you enter into a contract, you're not given a form, then, and there's no calling off notices, say you're a company buying a commercial property, no calling off rights, well, what happens then? A number of things can happen. Firstly, you have no calling off right contract. You may well have a remedy under Section 15, which you can show that you have been prejudiced by the fact that you haven't been informed month. That may not be straightforward. You need to show that you might have done something different had you been informed one, which you were not given, that may never get. So that's not straightforward. It's criminal offence not to give the form, so that's okay, but it doesn't help you as the buyer. So the idea, I think, is to make sure that you get this disclosure statement. There's quite a bit hangs on that. There are remedies, Section 15, which I chat about, if the form is defective, and there are many ways in which a form can be defective. And so that's kind of what you hang your hat on. So make sure you do that. And I think if you enter into a contract with no Form 1, some conditions of authentic position is problematic. In theory, you have remedies, but in practice, that may be quite hard to do. With the sale of a business, as I mentioned, it's a Form 2. And that is actually quite detailed. For the accountants here, I can just talk a bit about what goes into this Form 2. I happen to have one. Actually, it's the particular form that has to be filled out is prescribed, and there's a lot of detail. The weekly sales, the business income, overheads, depreciated value of public trading statements, a whole bunch of things, gross takings, profit from sales, a whole range of things. Not sure how relevant all these are to some businesses, but maybe they are. And then you end up with net profit. So and that goes back about 3 years. So it's very detailed. And the tricky bit is that that all needs to be accompanied by a certificate in a form which is prescribed by regulation. It's got to be signed by a qualified accountant. Probably seen some of this. And there's an interesting conflict between what Section 8 says about what this form actually has to do and what we can use. what the regulation actually says. They're not the same. So under this section that talks about giving this certificate, the statement, trading statement, needs to be in a form of a regulation. That's what that is. It has to be have endorsed on a certificate by an accountant who says that the accountant has examined the accounts of the business. Now, I guess they can do that, but query what are the accounts of the business, but anyway, certified to examine the accounts of the business and that the financial particulars disclosed appear to be in conformity with the accounts. That's a big statement. And it's a statement that accountants may not make. How would you know? How can you make that judgment? The trading statements or the accounts, I mean, you could make that statement, yes, but there may be circumstances in which they're not looking for. You're simply not aware of that. However, so that's all a bit grim. Fortunately, the regulations actually say something quite different. So keep this in mind if you're looking at one of these certificates. The particular form that has to be signed by the accountant is in the regulations here on the forms. It actually doesn't say that at all. What it says is that the accountant has examined the records, and the accountant giving this statement, the certificate, then has three things they can do. One of three things. They can say that in their opinion, the trading statement fairly and accurately represents the financial operation of the business. Right? That's, I guess, similar. Or they can say the trading statement fairly and accurately represents the financial operation of the business. Subject to the following qualifications. You can put a whole bunch of qualifications in there. Good. Thirdly, the trading statement may not fairly and accurately represent the statement of business. That's the one you probably end up doing if you could. So it's kind of unusual because the particular form of the regulations that talk about what the certificate says is not in conformity with the Act. It says something different, which I think is not helpful. It means that there's wiggle room in the nature of the certificate that has to be given by an accountant. So if you're doing one of these, or looking at one of these, the form has to be accurate at the time of service. And if you give a Form 1, this is an edit to, but if you give a Form 1, it needs to be accurate at the time it's given. But if you sign a contract later on and something changes by which the form that you've given is not accurate, then you've got to give another form. And if you don't do that, then the first Form 1 is defective and therefore useless, which means, particularly with someone that has a called offer, that prescribed time never arrives. Or if it arrives, it arrives at 7. So the form needs to be accurate, and normally the best thing to do is give the Form 1 and sign the contract at the same time to avoid that kind of issue. As I mentioned, there's a penalty of $10,000 if you don't comply with this. So there's a bit involved in all of that. And then we move on to remedies. And that's all dealt with in Section 15 of the Act, which basically says that if you give a Form 1 or a Form 2 that's defective, and the buyer has suffered some prejudice because of that, then the buyer can apply to a court for remedies. And that remedy might be just terminating the contract, or some damages of some sort, or making some further order that the court thinks should be made. So there's significant remedies available. The courts can basically do anything it wants. And so the idea is that there are two preconditions. Number one, it has to be defective. Number two, it has to be prejudice, some sort of reliance prejudice. So there are some defences to this. One is that the defect, non-contravention, or the contravention non-compliance was unintentional, didn't occur by some negligence, or the contravention was due to some reliance on information given by somebody else. Or you've excluded the obligation to give the form in the first place, which you can also do by sending a lawyer who signs a certificate that says, don't have the form at all. Otherwise, so that's a defence. It's an unusual way to do it, because if you don't give a form, that's an offence. And a defence to that, sorry, that's an offence, but a defence to that is that you've seen a solicitor, legal practitioner, who signed a certificate that said you don't need a form. That's a defence to a charge that you breach the Act. Funny way to do it, but broadly, you can do away with the requirement to have a form as long as you go through the certificate thing, which I was talking about earlier. So that can relate to either the waiver of performing off right or form at all. So this whole thing about remedies, I'll tell you a story about a file we had in here that actually went to the district court. Unusual matter. The client was called Nicole. She was the vendor of land and Liddell. The form one disclosure statement was prepared by a professional body that do this. Tuckfields get it. And part of that process is to ask whether the vendor was aware of any contamination reports affecting the land. Nicole was not aware of any, so she took note of that. And that no answer was in the form. Separate and apart from that, Tuckfields then did the usual searches, got the interest report from the council, arrangement of the searches, EPA search, Protection Authority search. And it turns out that the area in Benell where this house was situated is part of some suburb-wide EPA contamination ruling on the whole area. And all it says is that you can't take groundwater because that area was used years ago for dry cleaning operations. So you can't take, you wouldn't want to put groundwater in your scotch. It's low level contamination. But that exists on the public register. And so where the form talked about whether there was any EPA or something like report, the answer was yes. And that was, when the EPA letter referring to that was attached to the form. So the perfectly innocent on behalf of Nicole, she answered the question. The buyer, called him Glenn, clearly decided to want the property for whatever reason. And so we got letters from his lawyer saying the form is defective because Nicole should have said yes. In answer to the question of whether she knew about some environmental report, because it referred to a formal report, which she hadn't seen. So they alleged that answer should be yes. Even though she would have been saying yes about the report, she had no knowledge of it. So the idea was that they wanted us to acknowledge that the form was defective in this really slight way, so that prescribed time hadn't been. And they asked us to give another form, where instead of no, it said yes, give us another form, okay, that's what it was about. We said, yeah, that's not. They issued proceedings in the district court seeking orders that the contract be set aside. And it's not often where I have a degree of confidence that we're going to succeed. But on this occasion, I thought, gosh, I can't see why they would want to issue district court proceedings. Anyway, on we went. Poor old Glenn had to give evidence about whether he was aware of this environmental letter on the form that had been attached to the form. And it didn't help his case where he put the judge in the eye and said, I didn't read it. So after that, I think his lawyers would have taken him aside and said, dude, you're going to lose. So he capitulated, but not before we had in the district court serious cost, council prep, and all the rest of it. So, an unfortunate piece of litigation. Our client worked out a fine, got a bunch of costs, settled the contract. I mean, the buyer's position was not tenable. But nevertheless, the argument was all about whether this form was defective, even in that tiny little way, and whether as a result of that, the court could simply terminate the contract. I didn't think the court would ever do that, and it didn't. So that was an argument for real under Section 15 of the District Court. We had another matter in here where we're acting for the buyer, not the seller. Also, around the issue of Section 15 and the remedy for that. It involves some land down in Woodville South somewhere. The client bought the land some years ago for several $1 million. Turns out the land was an old munitions factory. Imagine what contamination was back on twins. Turns out there is contamination. It's all nasty. It's carcinogenic, nasty here. It's in the water. Water is lensing that way into residential areas. The EPA is really active in assessing what all this is and how it can all be remediated. Remediation's 7 figures to do that. So we looked at this. Our client received a Form 1 and it referred to a couple of environmental reports that the seller had done. And it just simply said, there's a report dated 2009, there's a report dated 2014, and copies are available for hire. Our client didn't ask for those. So the form was 100 pages. The 2 environmental reports, which we had actually got, but were not attached, were 300 pages and 400 pages. Had they been attached, I think it would have been about 1,000 pages, which is enormous. When our client purchased the property, the position with contamination is the EPA can chase whoever has caused the contamination, whether they're the owner or not. So if you have caused contamination, you can actually transfer the liability onto the shoulders of the buyer, but you need to comply with Section 103 of the EPA Act, and there's a procedure to follow there, which they have done. So on the face of it, the vendor had a liability for this cleanup. However, there was an indemnity in the contract by which our client, the purchaser, held the vendor indemnified for any liability for cleaning up. So therefore, that landed the whole issue back and how that began. So the question was whether this form was defective. The argument we would say, there's nothing in the Act that requires these reports to be attached, but nevertheless, our argument would be, well, we had them, we shouldn't attach them. And for that reason, the form is defective in that there's something missing. In that, even though they referred to this report, they didn't attach them, and therefore the form is defective, therefore we should get some reports. We never got to the stage of litigating. It's not, I guess, not bad in a way because it was commercially settled, which was probably sensible. Because I think even though our argument was a solid argument, the other side would have said, yeah, we don't have to attach it, so I'm not going to. But it would have been really interesting to examine their file and see if there was an email between the directors where one director says, no, look, we've got this form, but don't stick it in the form. Whatever you do, just refer to it, just keep it all on the QT. But we never got to that stage because it was commercially settled, which was a bit of a pity. It would have been interesting to know whether a form can be defective because you have something that, although not strictly required to disclose, you just choose not to disclose it, and therefore it's missing important information. We might have struggled to show reliance as well. Would we have done things differently? So it's one of those things, settled, money changed hands, and That's how it works. And finally, I'll just talk about a remedy in the business sale context in the case of Catalano. Catalano involved a purchase of a business called Brighton Clean. It was a car washing business. And it turns out that the seller was 75% reliant on a contract with Fleet SA for all their cleaning their vehicles. But it transpired that Fleet SA had given notice of terminating the contract, and that fact was not disclosed to the buyer. We just went ahead anyway. And there's a bit in the Form 2 where the seller has to disclose anything known to the seller which would adversely affect the business. So you can see that the level of disclosure required in the business is quite a bit broader than sale of land. In this case, they disclosed that. They did get that to themselves. So the word defective is not defined, but the court said, yeah, well, defective means there's something lacking. I think it's pretty clear that not disclosing imminent termination of the major business was lacking. So that, and then, as I mentioned, you need to prove reliance on whatever it is that you're being misled over. And the court basically said, well, look, I mean, no one in the right mind would have put this business if they'd known what this contract was going to terminate. And so it was easy enough, first of all, to show what in fact the defect was and reliance and prejudice. So all of those things sort of hung together, as you'd expect. And Catalano, I think the contract was terminated, had to be repaid. So that's a bit of an idea about what happens with the sale of the business, and particularly around the Section 15 remedies, and there are the other cases as well. But the court, as I say, it has broad powers, and certainly with a Form 1, which is a very detailed form of interest report, various disclosures, it's not hard for it to be effective. So the Act goes on to talk about other provisions. There's a bit of a grab bag of provisions excuse me, around sales of subdivided land. And there must have been at some stage some issues with sales of subdivided land, because there's a bit of detail on offences committed for conduct within the sale of subdivided land. For example, you can't induce someone to buy subdivided land on the expectation that they're going to receive a profit later on. Maybe they're promoting subdivided projects and things, maybe they do that sort of stuff. So that's an offence, and also contract can be avoided. So there are rules around those sort of inducement things. The inducement into a contract on the promise of something occurring. Likewise, if there's some unreasonable or undue persuasion into a contract by subdivided land, it's not clear what unreasonable or undue persuasion is. By definition, agents acting for a vendor will use powers of persuasion or not. So it's really a question of what is undue persuasion or unreasonable persuasion. Anyway, that's it. I couldn't find any cases on that. I haven't been litigated before, but that's in there. There are a range of provisions dealing with land agents and the conduct of land agents that they operate. That is the sales agency agreements. There are a whole bunch of rules around how those agreements can terminate, what notices have to be given, how they can be extended. They can only be extended once. Really extensive. Also about obtaining a commission from some third party to facilitate some contract. That would never be a secret commission anyway, but it might be. But how a commission to operate, in particular secret commissions, where an agent receives something without people knowing about it. I didn't have time to go through all of those. In fact, really running through all those provisions about land agents will take another session completely. They're detailed. Some other provisions around collusive dealing. Collusive dealing where parties get together and effectively conspire, say at an auction, where person A is going to buy an auction, and then also the real buyer comes along afterwards as the real buyer. That used to happen. That's also an offence where you're involved in this collusive practice. So I think that all arose out of a bit of an effort to sort of clean up the whole land agency business, which for the most part is pretty good. But that's where that can come from, where auctions can be manipulated in that way. And people bids and all those things. So there's detail about all of that. There are provisions related to conveyances, not particularly interesting, although we operate our business in the firm. And finally, there are some miscellaneous type provisions picking up false misleading representations. Again, penalties around this, $20,000 imprisonment for a year, that's very serious. False or misleading representation for the purpose of inducing a person to buy land. That's pretty general. I couldn't find a reason for litigation on that, but there may have been some prosecutions around it. Again, it's not clear on what a false or misleading representation would be and whether it amounts to an inducement. However, it's very broad. It's in there, section 36. There is a offence, that is, that whoever was making representation believed it to be true or had reasonable grounds for believing it to be true. So, as I mentioned, broadly, the Act, it's all about disclosure, creates rights, sets up rights to get out of contracts, sets up an obligation to give accurate disclosure of a whole range of things related to land, a whole range of things relating to the stuff of business, particularly around financial performance. There are certain with that. It creates the right to get out of these contracts. Well, and spend a bit of time on section 15 that creates remedies that will potentially apply at the active if you are dealing with a disclosure that's misleading or false in some way. So I've endeavoured to keep the whole discussion reasonably light, put in a couple of true stories as well. And I'll be pleased to take your questions.